The 4 basic components to winning evidence, coming up right after this.
Yes.
Hey everyone, welcome back to the Mr. Small Claims Court YouTube channel. I'm Jordan Farkas. I'm a retired attorney as well as author of various books on small claims court, and very grateful to have you back on my channel. I hope you've watched the introductory video, first of all, on my home page of the YouTube channel. That's actually for those who haven't subscribed. So if you wanted to learn a little bit more about me, you can check out that video, and I'd be very grateful if you've subscribed. If you have subscribed, thank you so much for doing that. Always appreciate that. And I'm always appreciative of any feedback or comments that you want to put in any of the descriptions of any of the videos. It can also help me do a future video on any topic that may be of interest to you. In any case, this is video number 4. It's kind of a series that I've been doing. I didn't set out to actually intentionally go in chronological order of a small claims court lawsuit, but it's kind of been unfolding that way. So you can check out the first 3 videos that I've recorded for you on my channel. And in today's video, I'm going to talk about what are the 4 components that are necessary to have winning evidence in the small claims court. And as usual, I always give the disclaimer because I'm a retired attorney, but you really can't shake the attorney out of anybody, unfortunately. Some of my friends call themselves recovering attorneys. In any case, I do want to give the disclaimer, as I always do, that every court in every jurisdiction will have its own set of procedure and rules and evidentiary requirements. So it's very hard for a global audience such as that on YouTube to give a sort of one-size-fits-all type of tutorial. But that said, there are some basic principles that you can certainly learn and apply to for your own specific case. And these are the kind of tried and tested methods that I've learned from my experience being a small claims court lawyer that I hope to pass on to you so that it will help you win in small claims court, because that's my goal for you, which is to help you win in small claims court by giving you this information in these videos. So without further ado, I did my usual, whatever the expression is, rough trod chart over here. Once I improve in my video editing skills, I'll be able to do this digitally for you, in case you're wondering, like, why is he doing an old school, old-fashioned whiteboard? And the reason is simply because I'm more interested at this point in getting you the content as opposed to worrying about the beautiful production design, but that's definitely something that's in the works. So bear with me for now. Maybe one day I'll look back at this video. I'm recording it as of October 2024. I'll look back fondly and laugh at the poor video quality and also microphone, I should say. I have got my mic over here just out of the screen. In any case, hopefully you'll appreciate the content that I'm offering you. That's the most important. That hopefully is what you're most interested in, how you can get the content you need to help you win in small claims court. If you've come to my channel or kind of fallen into it and fallen onto this video, then chances are you were looking for some small claims court help. So I'm happy to be that kind of messenger to help you out. So without, I already said without further ado, again, verbose lawyer is kind of in the blood once you've been practicing as an attorney. Without further ado times twice, here's what I've jotted down in terms of what I mean by winning evidence. By the way, I do want to say also that when I say winning evidence, what do I mean by that? Well, what's evidence? Okay, so evidence is basically what you need to help you prove your case. And that can take many forms, particularly in small claims court, where the rules of procedure are generally a lot looser and less rigorous than they would be in a higher court setting. Small claims court tends to be more chilled out. So again, in most courts, I can't speak for your specific court where you're watching this from, but in most small claims courts, that could be text messages, that could be emails, that could be invoices, contracts, any sort of written proof that you can produce, that you can show to the court, you can show to the judge or the decision maker, the arbitrator, whoever's making the decision for you in the small claims court in your jurisdiction. That could be audio recordings even. There may be some rules about how you have to introduce all this evidence, but a lot of times that could include audio, that could include video, even if the court has that capability to allow video communications. It could also include testimony. So that means you have somebody come into court and testify on your behalf. That could be a regular Joe, so to speak, or it could be an expert witness. There's all sorts of different types of evidence, and I'm actually going to get into that in a future video. And I think I'm going to do it by using like a concrete example. But the point of this video is kind of to introduce to you the idea of what evidence you would need in order to help you win your case. And once you have a sense of what that evidence is, I can walk you through this using an example in, I think will be the next video, to help you understand how you can actually get that evidence and apply it to helping you win your case. But for now, let's go over like a little general overview of the types of what the evidence is that you need to help you prove your case. So number one here is that the evidence must link the defendant to your lawsuit. And if you've watched the first video that I did, I talked about the idea of making sure that you name the defendant properly and you choose the right defendant, because it's not always clear cut who you should be suing in the first place. Or maybe it is clear cut, but that's clear cut for you, but you want to make sure the judge understands that the person who you sued is the right person. So in a very simple example, again, I'm going to get into more concrete examples with specific evidence examples in the next video, but for this purposes, an example would be, let's say you're a contractor and you had a contract with John Smith. I'm just taking a random name, and his resemblance to an actual John Smith is coincidental. Sorry, John Smith, if that happens to be your name and you're watching this. So let's say you're a contractor and you had a contract with John Smith that you would do a renovation work for him, and he would pay you $10,000 to do that work, and then you did the work and he hasn't paid you. So there's a very simple example of who the proper defendant should be. That should be John Smith. That's the person you had a contract with. Obviously, things could get a lot more convoluted. I'm not going to go over the whole, what I discussed in video one, but a lot of times when it's not so clear cut who you had the contract with or who was supposed to be paying and when, then it could get a little bit more difficult. And that's where evidence could be really important to make sure that you really nail down who it is that owes you the money. But even in a very simple example, you have to remember the judge is going into this cold. So the judge doesn't know all the facts or the history or what happened. So you want to make sure that your evidence will help you link what transpired between you and the person you sued and prove that the person you sued is actually the person who owes you the money. And generally that can be done with a contract, if you had a written contract. Otherwise, you're going to have to come up with ways to prove that. And we'll get into the next video how specific types of evidence could help you prove that. So that's number one on my list. You want to make sure that you're actually linking the defendant so that the judge could actually make a judgment for you against that defendant. Because if the judge isn't satisfied that this is the right defendant or the right party, then you're not going to win your case. So make sure that you have evidence that proves that the person who you say owes you the money is the person who actually is the one who owes you the money and is the one who actually caused you damages, the one who actually wronged you. That's number one. Number two is what happened. By the way, a lot of this may sound obvious, and if it does, in a way, I'm gratified, because sometimes what is presented to you is presented in a way that makes it sound obvious, but if it's not presented to you, you may not realize it, or maybe it's so obvious that you don't even think about it. So this is kind of reinforcing that for you. Either way, that's not a bad thing. Okay, so if it does sound obvious, that's fine, but it's always important to make sure that you cover these boxes, you check off these boxes to make sure that you have the evidence that you need to win. So what happened is obviously crucial to helping the judge understand the story. Now, I've talked about this in past videos already, where you kind of want to make sure you're not getting into irrelevant details. And you would be amazed. I can tell you stories from when I was a practicing small claims court lawyer, and the amount of information. So I would ask my clients to send me, synopsis of what transpired, because I would be helping them prepare their lawsuits and, getting into describing the chronology for the judge. And a big bulk of the work that I would do would be to kind of filter out all the extraneous background noise, so to speak, that clients were sending me, and get to the actual, what the lawyers would call salient details, the specifics of what you need to prove your case. So when I say what happened, that doesn't mean you give an entire backstory from 1952 as to what happened. That means specifically what the relevant dates are. So for example, if you had a contract, what date was the contract? Who was the contract with? When was the work supposed to be performed? A lot of this has to do with dates. You want to give that chronology to the judge so that the judge knows, what actually transpired and when. So it's always very important to make sure that you have evidence that can prove the chronology of when things, the important things that happened in your case happened and what happened exactly. You did the work. You want to be able to prove, obviously, that you did the work. You want to prove that this person was supposed to pay you on such and such date. The person didn't pay you, what you did, what happened next. Okay, so all the important facts, it's very important that you can make sure that you come with receipts, as a common terminology these days. You want to be able to prove that you actually did what you said you were supposed to do for this person, in our example of a construction contract, and that the person didn't do what he or she was supposed to do, in our example of person John Smith not paying you for the contracting work that you did. So that's number one. We've got, like I said, linking the defendant, and number two is what happened. Number three on the list for, what you need your evidence to prove is how much. Again, sounds very obvious, right? But you would be amazed again at how many clients that would be in touch with me, and they'd give me a whole long story, and I'd be like, okay, well, you're saying you're owed $10,000. I'm just taking a round number. Where I don't see anywhere in anything that you said that shows this. So you really have to be mindful of the fact that you're asking a third party, a judge, a decision maker, to make an award to you in an amount of money that you say is owed to you, but you have to be able to prove that. You have to be able to show that to the judge. Okay, and we'll get into the next video what that may take the form of. That may be, again, in a contract, it may be receipts and invoices and emails and texts and all sorts of different ways that you can prove that. But the key point here is to make sure that your evidence that you are bringing to the trial does show how much, not just what happened and not just that this person screwed you over, but also how much this person screwed you over for, pardon my colorful language, but how much money you're actually owed. Because without that, there's no judge in the world who's going to be able to give you the judgment that you want. And finally, we've got, and number 4 here, make sure you have evidence that could disprove what the defendant is saying, okay? Now, this is tricky in many instances because in some courts, based on my reading of the current state at the New York Small Claims Court, for example, it's not so clear to me that you get a chance to see that evidence of the defendant before you actually get to trial. Of course, there are mechanisms such as adjournments. Adjournments means you ask the judge to delay the hearing, to stop the proceeding that day and maybe come back another day so that you can gather more evidence. By the way, that's another hack. That you don't always have to proceed with trial if you're not ready. If you find that you get to court and there's some surprise waiting for you, there's some witness that the defendant brought or some sort of documents that the defendant provided to you or to the court for the first time and you've never seen it before, it doesn't mean that all hope is lost. You can always ask the judge to give you what's known as an adjournment. In some places, it may be known as a continuance, but just to give you that time to be able to gather yourself and get more evidence. So don't give up if you didn't come to court in the first place with evidence, but obviously it's always within the judge's discretion whether or not to give you that adjournment. So you want to put your best foot forward and bring that evidence right away. And when I say here to disprove the evidence, to disprove what the defendant is saying, the reason I say it's tricky is, like I said, if the defendant doesn't provide that to you beforehand, that can be very tricky. But let's assume that you do have a kind of a glimpse of what the defendant's saying. So maybe John Smith sent you an email back saying, no, I'm not paying you a nickel because the work you did was terrible. So not only do you have to prove that you did the work for John Smith, but you also have to prove why your work was not bad. Okay, the onus of proof, if you're the one who's suing John, you're the one who has to satisfy the judge that you're owed the money. And if you already know that John Smith is going to say in response that the work you did was shoddy, then you want to be able to be prepared for that in order to argue that it was not shoddy. So that may be a classic example, maybe if you have an expert witness, a third party, expert contractor who's been in business for 30 years and can tell the difference between shoddy work and good work, you want to make sure that you have that person who's with you to testify if need be. Obviously, that person would have had to visit the property and inspect it. So there's all sorts of caveats that come with that. Again, I'm giving kind of a simple overview here. It could get really nitty gritty once you start drilling down into all the different twists and turns that evidence could take. But that's the point. You want to be able to refute what the defendant is saying. And in many cases, you will have an idea. There are cases, obviously, where you do the work and you never hear from the person again. And that's a little bit more challenging because you don't always know what to expect. Again, in those instances, if you didn't come anticipating what the defendant would say because you didn't know and you were surprised, don't think all is lost. You can hopefully get that adjournment once you're at the trial. But in cases where you do have responses from the defendants and you have communications and all sorts of exchanges between you and the defendant, and you have a sense of what the defendant is going to say, will come prepared to be able to refute that at court. Okay, so just to summarize, we've got basically 4 ingredients for winning evidence in small claims court. Number 1 is making sure that you have evidence that will link the defendant, the person that you've sued, to your lawsuit to make sure that the judge is satisfied that this person indeed is the one who owes you the money. Number 2, we've got the evidence of what happened, proving the chronology of what actually transpired between you and the defendant. And remember, that means the salient details, the relevant and necessary facts, and leaving out all the stuff that isn't important to your case. Number 3 is how much money is owed to you. Okay, that's what it's all about. It's about winning money in court. There are some courts where you can get some other types of relief and awards from the judge. There's places where you can get what's known as an injunction, where you're asking somebody to stop something, but usually that's not something within the jurisdiction of small claims court. So assuming we're dealing with a monetary dispute, a dispute over money, you have to be able to satisfy the judge, the decision maker, how much money this person actually owes you. So you better come ready with evidence for that. And finally, number 4 is having evidence that will refute and disprove what the defendant has been saying in response, okay? Because if you already know that the defendant has excuses, you may call it, the defendant may call it a defense, you may call it an excuse, but whatever the case is, make sure you come with evidence that can refute that so that you're in a much better position to satisfy the judge that the defendant is not the right party here. You are the right party. You are the one who's owed the money. You're the one who deserves to win. Okay, so again, that was very general. Stay tuned for the next video if you want to get a more in-depth analysis of how you would apply that evidence for your case, what that evidence may look like. I'm going to try and give it a specific example. I'll probably use the same contractor dispute that I used now. You can always leave in the feedback if you want me to use a different example. Again, I won't be giving you or anybody else who watches this video specific legal advice, but you're certainly welcome to leave comments and take a shot. You know, you could leave a little bit of details about your case if you want, and it may just be the subject of a future video. And that way we'll be helping each other in that regard. You'll be helping me by giving me some more material to provide to you, my audience, and I can be helping you by giving you my thoughts on that material that you'd like me to share on. So I hope you found that video helpful. As always, if you've subscribed, thank you so much. If you haven't yet, I'd be grateful if you took a second to hit that subscribe button and to click or smash or hit the notifications button, which will allow you to not miss a future video and definitely helps me grow this channel, which helps me continue to put out videos just like this one to help you win in small claims court, which is my goal for you. Until then, looking forward to seeing you at the next video. Hey, if you like that video and you feel it's going to help you win in small claims court, check out the next video I've got queued up for you. If you haven't already done so, I'd be very appreciative if you hit that subscribe button and the notifications. Definitely helps me, but it will help you not miss a future video to help you win in small claims court. Don't forget to hit that like button and also feel free to leave a comment, and I'll see you at the next one.